All right, good morning, everybody. Thank you so much for joining us this morning. We've got very esteemed guests joining us this morning, Leigh-Anne Harrison Richards, who you all know, who is a property manager at RPA, property administrators, a managing agent, but also a legal eagle. Leigh-Anne used to work with me when we were both managing agents at Pam Golding Property Management Services, and assists us very often with consulting work as well as a consultant, goes to some meetings for us, and then of course is the expert when it comes to Property Practitioners Act and Poppy, as many of you will recognize her from the webinars that we did with Poppy. Our other guest speaker that we have today is Dilen Heerschop. Dilen, did I say that correctly? Was it Afrikaans enough for you? Okay, good, fantastic. And Dilen is from Schuller, Heerschop and Pienaar attorneys based in Johannesburg and Cape Town. Dilen is an expert in the Property Practitioners Act. For those of you that follow him on social media, you would see that. And he recently spoke at the NAMA functions around the country on this particular topic of the Property Practitioners Act. Leigh-Anne and Dilen have been working quite diligently the last couple of weeks in preparing as much information on the Property Practitioners Act for the industry. We specifically are assisting our managing agent clients. And then, of course, Dilen will share with you the services that his firm offers. Leigh-Anne's contact details and Dilen's contact details will be shared during the course of the presentation as well. Please keep an eye out on the chat function. If you do not get those contact details, please do pop us a mail as well. Nicole, I see that you just have to pop that one again. I see we unfortunately spelled Heerschop incorrectly. It's rather complicated, but then again, my first name gets spelled incorrectly all the time as well, so I won't feel too bad. So without further ado, I'd like to hand you over to Leigh-Anne. We will deal with some administration before I forget. The session is being recorded. A copy of the recording will be made available on our website, as well as the presentation that Leigh-Anne is sharing and the contact details of both Leigh-Anne and Dilen that you're able to make contact with them. Please remember to sign up for our newsletter if you have not yet done so. And then today is D-Day. Close of business today is D-Day for anybody that wishes to lodge any type of complaint that they might have against the Community Scheme Ombud Service. Those of you that follow us on social media would have seen that we have been working with the DA Shadow Minister of Human Settlements in regard to the processes and procedures of the Community Scheme Ombud Service and where they get things wrong, including incorrect adjudication orders. We've been quite fortunate to work with the DA, although we're not political people at all, but the DA just so happened to be the first political party that answered the knock on the door when our colleague in the industry, Teresa Williams, that you might know from the Sectional Title Living in South Africa Facebook group, spent over a year harassing the political parties to get some assistance in regard to the functioning of the Community Scheme Ombud Service. So you have until close of business today to follow the link that Nicole will be sharing on the chat function to lodge any type of complaint against the Community Scheme Ombud Service. If you don't wish for your details to be shared, you are more than welcome to share that information with us. Nicole, if you can just share my email address as well, that'll be great. All right, now that's all over with. Leigh-Anne, over to you.
Thank you, Celinda. Thanks everybody for joining this morning, and a huge thank you to Dilen for assisting me this morning. It's been great working with you, and I look forward to continuing working with you as well as TVDM consultants. Over the past three to 4 months, I've been working on the Property Practitioners Act. I've attended many webinars, read articles, so there's a lot of information out there, and this is in no way a means of just, sending you information or showing you information. We want to make sure that everything is as easily understandable as possible. And then again, as Linda mentioned, we'll answer as many questions as we can towards the end of the webinar. And again, if you have any questions, then you pop Celinda or Nicole or myself or Dilen an email as well, and we'll happily assist you. So once again, thank you for joining us, and I look forward to this morning. All right, so this morning we're talking about, again, the Property Practitioners Act. Just to follow on the first webinar we did about a month ago. So we'll go into further detail on a few aspects. We're not addressing every single aspect of the Act or its regulations. And again, if you have questions on that, it's best to contact Zelinda and her team. The first item I want to chat about, again, just what the Act has now done is it's included managing agents as a property practitioner, which in terms of the Act means any person who manages a property. That's basically the crux of what the Act states. The EAAB was replaced by the Property Practitioners Regulatory Authority, the PPRA for short. And they've actually, the website has now changed. It's now the ppra.org.za. So if you want to go on the website, a few things have changed. They make reference now to the PPRA and not the EAAB. There is a lot still that has to change, and I'm sure eventually they'll get there. So again, only time will tell on that. What the Act prescribes is that every property practitioner must apply to the authority for the issuing of a registration certificate as a property practitioner. One has until October this year to do so, and the application and all the details regarding that you can find in the regulations that are linked to the Act. Again, if you struggle to find them, you can ask Linda for them. Otherwise, I usually find them on the government websites. I downloaded both pieces of legislation. Once you make application, you have, or the PPRA has 30 days within which to issue a certificate. They can request a 20-day extension if there are any issues with the application. And if not, you then have a further 10, you can request a further 10 days for them to issue the application or the registration certificate. However, historically with the EAB, timeframes aren't necessarily a strong suit. So what they have mentioned in the Act is that if you make an application and the time periods for in which they have to issue the certificate expires, you will then have been deemed to have been issued a certificate. When it comes to the registration applications, the timeframes they've issued, the same applies to Fidelity Fund applications, which we'll touch on later. So the exact same timeframes will apply when applying for Fidelity Fund certificates. I want to now hand over to Dilen to continue on this discussion.
Yeah, thank you, Leigh-Anne. So just from a practical perspective, I think it's important that we should consider something, and it's quite an irregularity, and it's, in my view, a cause of concern. I mean, we've been dealing with the PPRA now for 2 months, since the 1st of February. And when one considers the registration document to now get this registration certificate, one would see that it still only makes reference to estate agents, whether that's now the principal estate agent or intern estate agent. So when completing this document, it seems that it's really quite confusing for us to now try and ascertain, especially where we are not estate agents, we're managing agents or rental agents, for example. It's quite a difficult task to try and complete this document. One can only hope that they're in the process now of trying to amend this document so to accommodate the industry and accommodate managing and rental agents trying now to register as this property practitioner. But the advice that I would forward when dealing with this registration is I think the consequences for leaving the registration as a result of these difficulties is really quite severe. And I don't think it's a good idea that the industry should just refrain from trying to register. So my advice would be try and complete this document as far as you can to try and just to get this registration in. Because I don't want a situation where the PPRA now comes back to our clients saying that, listen, you've not registered, you're in complete contravention of the Act. So even though the registration document is going to be confusing and it's going to be definitely a mammoth task to try and fit the managing agent context into that document, but just try and complete the document, and we can then at a later stage try and contact the PPRA, or they might change their documents so that we can then complete an amended one which actually suits the industry. As Leigh-Anne discussed, the next hot topic that we're going to discuss is the fidelity aspect of the Fidelity Fund certificate. So the first thing is, in terms of section 47(1) of the Act, every property practitioner must, in a 3-year cycle, apply to the PPRA for the issuing of their Fidelity Fund certificate. So I think a good question would be, but who are these people? I've had this question raised multiple times. I don't think I can even count the amount of times that they've asked, but who in the industry should now be considered to have this Fidelity Fund certificate? So every property practitioner, by the definition, and I think it's going to take this webinar, had we had to go through the whole definition of a property practitioner, which is in excess of 2 pages, we would have been here the whole day to try and sort this whole situation out. But just in short, and for the industry that we're dealing with, it relates to any individual who manages property. So there is a few exemptions to the rule. Regulation 25(2) says that no person who does not directly carry out any material degree, any activity or function of a property practitioner is required to register with the authority or hold an FFC, regardless of the fact that such person may be employed by or in any way engaging with the property practitioner. But again, the situation that we're faced with is that there's no guidance at the moment relating to what do they now consider this directly carrying out any function. So the problem with this, and the question that's been posed to me is, should a portfolio manager have an FFC? So when we look at the strict interpretation of the Act, it seems to suggest that basically everyone in your office, apart from the cleaner and the receptionist, is considered to be this property practitioner, and that they would then in turn have to have a Fidelity Fund certificate. Our view on this, and specifically in relation to Regulation 25(2), is we should not steer away from the purpose of a Fidelity Fund certificate. So a Fidelity Fund certificate is there, it's a type of insurance or indemnity as a result arising out of loss that is now incurred by this community scheme as a result of theft of trust money. So my view on this is, if you can't get your hands on the proverbial cookie jar of the community scheme, one would have no need to obtain this Fidelity Fund certificate, because you would then not have to enjoy this coverage, as you would not be in a position to meaningfully now appropriate this trust money. So that's our view on it. Again, we're waiting for guidance from the PPRA to tell us now what is this direct involvement. Are they going to exclude PMs? But for now, we should accept the position that any PM must hold an FFC, or rather that a PM is seen as a property practitioner. But I think this is going to be a hotly debated topic. I'm currently involved with NAMA, trying to see if we can't get an industry-wide exemption, to try and see if we can't exempt these requirements, especially where the PM does not have access to the trust funds. If you can't pay the funds out of the trust account, there is no risk and there is no reason that one would need an FFC. But again, our view may differ from what the PPRA's view is, so we will have to wait. But luckily, we've got until October to try and rattle some cages at the PPRA and to try and see whether or not we can get this exemption for the industry, because I think it's a problem that's going to be faced with all of the industry players. All of the managing agents are going to have this headache. So let's see if we can't try and ventilate this issue with the Property Practitioners Regulatory Authority. Then some additional, and it's worth noting, things relating to Fidelity Fund certificate. The first thing that we must take note of is that when we now dealing as this property practitioner, when we sending any correspondence or any letters or any marketing material, we must understand that the phrase registered with the PPRA must appear on these documents. So I think if there's one thing that we can take from this seminar and a proactive step that we can actually now implement in our own businesses, is to include this phrase in our letterheads, in our email signatures, and if we are now going to print or market in some other manner, ensure that we include this clause. Another thing that we need to ensure that is also in our agreements, any agreement in connection with a property transaction to which the property practitioner is a party must contain a clause in the following terms. So just to give you a bit of to broaden it down in a management perspective or managing agent perspective, this means the management agreement. We're going to have to amend our management agreement so that we include this clause. The clause would start by saying ABC property practitioner or ABC managing agency or whatever the case may be hereby warrants the validity of his, her, or its fidelity fund certificate as at the date of signature of this agreement. And then just lastly, dealing with the mandatory display of our fidelity fund certificates. So the Act and the regulations are quite clear. The certificate must be displayed in every place of business from where the property practitioner conducts property transactions. This is to ensure that the consumer are easily able to inspect the certificate. Now, luckily, when issuing these fidelity fund certificates, there is a little business card type of fidelity fund. It's literally on the certificate. There's a little business card size fidelity fund confirmation. Just cut that bad boy out and keep it in your wallet. So when we're dealing with our consumers, that they are well aware that we have this fidelity fund certificate. And something that's very important that we should note with the fidelity fund aspect is the Act is quite clear, and it says the moment we don't have a fidelity fund certificate, a valid fidelity fund certificate, property practitioners are not entitled to remuneration. So it's very important that we take the necessary steps to obtain this fidelity fund certificate. Leigh-Anne, back to you.
Thank you, Dilen. Thank you for that. And definitely a hot topic. And I think this is going to be one of the sort of the main items that we'll be discussing or definitely in the industry over the next 6 months. So thank you for that. What I'd like to chat about is trust accounts. What the Act states is that every property practitioner must open and keep one or more separate trust accounts. Once you've opened the trust account, appoint an auditor, and thereafter provide the PPRA with all the information in respect of the account and the auditor. And in that respect, the Act is quite specific, and the regulations, they refer to, in terms of the trust account, name of the bank, the branch, the account holder, the account name, all those details. And for the auditor as well, their name, address, contact information. They are quite specific on that. So if you ever have any doubts, you can refer back to the legislation on that. There are exemptions that the Act has provided when opening a trust account, where the account is open in name of the body corporate, where you've opened the account in their name and not a trust account with the managing agent, then you are exempt. Or if the practitioner has never or will no longer receive trust funds. There is an affidavit that needs to be completed in that respect and submitted. Again, the regulations do set out the complete affidavit. You can print it, copy it, complete it, and then take it to the police station or get a commissioner to sign. So it's important that when dealing with a trust account, if you want exemption, you have to comply and submit the affidavit. It won't just be automatic. When appointing an auditor as well, there is an exemption. If your turnover is less than 2.5 million rand, you don't need to appoint an auditor. You do, however, have to cause your accounting records to be reviewed by a registered accountant. So it's important that when you're looking at the legislation or the regulations, comply with them, and if not, if your company falls within the exemption, then you just have to get them reviewed by an accountant. So that's just a small touch on trust accounts. If there are any questions, then we'll happily answer them towards the end. The next item, and again, I'm not going to touch too much on this because there hasn't been much talk from the PPRA side on this. What the Act requires in terms of the qualification requirements for, again, property practitioners, and whoever else falls under the definition. The PPRA is to establish qualification standards to enable persons to qualify as property practitioners, which shall include a practical training course of a minimum of 6 modules to be completed over a maximum period of 6 months. It also makes reference to the PPRA making arrangements for the PDE, professional designation examinations, to be written 4 times per annum at intervals determined by the authority. But at the time, or at the current time, this hasn't been established as yet by the PPRA. With discussion with a few of my colleagues, as well as Dilen and his brother, what we think may or may not happen is they will bring it in line with what's already established prior to 1 February. But again, only time will tell. So I know Dilen has some thoughts on this.
Yeah, so just to come back to what you've mentioned, in regards to the standard of training, we've got the 6 modules. What they will entail, we don't know. What it will cost, we don't know. The only thing that the Act makes reference to is that we have to complete these 6 modules within a maximum period of 6 months. Something that's interesting, and I think this is now an opportunity for NAMA to get their hands on this, is this standard of training. Private individuals can get recognition for us to now obtain the standard of training from them. So I think personally, in my view, what would be great in this instance, if there is a industry specific, for example, a managing agent course, where one would then actually only deal with aspects relating to a managing agent. I think a lot of property practitioners, whether that's now a rental, estate, or managing agent, is quite reluctant now to try and obtain all of this knowledge relating to all of these industries. So I sincerely hope that we get a qualification standard which is specific to the respective agent who we are. But again, as Leigh-Anne mentioned, we do not quite yet know what is going on. And I think this is a serious concern, considering that we've been in this role of a property practitioner for 2 months from the 1st of February, and we've still not received any guidance in relation to our qualification requirements.
Thank you, Dilen. The next item I'd also like Dilen to chat about regarding the Section 58 of the Property Practitioners Act regarding relationships with service providers. What the Act states is that a practitioner may not enter into any agreement, informal or formal, whereby a consumer is obliged or encouraged to use a particular service provider. In practical terms, what I like to say is that a managing agent may not receive any commission or payment, whether they have previously or continue to do so, favor one service provider over another in exchange for remuneration or gifting. It is a very tricky and touchy subject, and I think, again, time will tell as to how this will be applied. I know Dilen has some thoughts on it as well.
Yeah, thank you, Leigh-Anne. So firstly, the one thing that I want to touch on here is the Property Practitioners Act is a consumer-focused act. So we can see this trend in legislation for the past few years, having the National Credit Act, the Consumer Protection Act, the Property Practitioners Act, POPI, and all of this. It's focused on putting the rights back into the consumer's hand. In terms of the Constitution, we have the right of freedom of choice. We have the right of ownership to property, and we can now dictate what we will do with our property on our own terms. So without delving too much into this situation, we must just bear in mind that we're putting the right back into the owner's hands, or the right back into the community scheme's hands, to make the decision to utilize. We cannot simply, as an agency, force them or encourage them, as the Act says, to use a particular service provider. This does not mean that we can't assist them in this regard. This does not mean we can't help them. We need to now drastically change our own practices, requiring the trustees now to obtain, for example, 3 quotes and making the decision. This simply means we can no longer try and impose who they should use. We can, in an advisory role, we can still help them to try and navigate these difficult waters in relation to a service provider, but we can simply not oblige them to try and utilize a specific service provider.
Thanks, Dilen. And in my line of work as well, I'm a portfolio manager. I deal with service providers every day, all day, along with my team. And practically speaking, if I've got a specification for work to be done, we send it out to tenders perhaps, and then we get the quotations back, and practically we just advise them, okay, A says this, B says the same, the prices are around the same, but then again, we advise our trustees and our body corporates, this is our recommendation, but again, we rely on them to make the ultimate decision. We don't push them in one direction or the other, and definitely there's no, the idea is we don't get any favorable commission or payment after the fact. It's just, besides the fact that it's in contravention of the Act, it's unethical, and definitely something that we strive towards not doing whatsoever. So definitely important that this is placed in the Act, and again, time will tell as to how this will be implemented and how managing agents will fare with this clause as well. Just following on this, I wanted to touch quickly on Dilen's comment on this is a piece of consumer legislation protecting the consumer. And what the Act has also done is it's created a further code of conduct, and now for property practitioners being managing agents where we have to comply. And what the Act does is creates a vehicle for dispute resolution. It sets it out quite nicely in the Act and the regulations, the process to follow, similarly, but not altogether similar to CSOS, whereby you can lodge a complaint and there's a form to complete. The PPRA will then follow the process whereby there will be conciliation and adjudication, etc. So it's now creating a vehicle where if someone's unhappy with a managing agent or a service provided or something along those lines, in contravention with the Code of Conduct or the Act, a consumer can now approach the authority and they would then have to deal with the complaint in line with the Act. Something very important to note as well. And again, we'll see how the complaint process will fare in line with the Act. That is our presentation this morning. I didn't want to keep it too long because I know we've been bombarded with webinars, articles, and the rest. So over to Zelinda, and then you can discuss the questions if we have any.
Fantastic. Thank you so much, Leigh-Anne and Dilen. I really appreciate your time and your knowledge, and I'm sure that the attendees do as well. So far, we've got one question in the group, and of course, people can raise their hands, alternatively, pop it in the chat function. We're more than happy to take it. We do have some time. So the question is, in terms of the regs, PPs include a scheme executive under the regulations on community schemes ombuds service. Does this mean that all trustees need to register as well?
Yeah, I think this is a very interesting question, and I've had it posed as well. So when one looks at the definition, where we now fall in as a managing agency, it says it's an entity who manages on behalf of another for remuneration. So again, the interpretation of on behalf of another is where the concern comes in. Because I mean, as an owner, you can make the argument that a trustee manages on behalf of the owners. But again, and then we're dealing with the remuneration aspect as well. But I think had this piece of legislation been to such an extent that it had to include all of these role players, it would have been, it's a mammoth task. I don't think we will have trustees being in this capacity. But again, as I've mentioned, we don't have guidance on these points. I would have appreciated some other form of guidance. Something that's also just worth mentioning, it doesn't relate to the question, but this Act also regulates executive managing agents. And I mean, that prohibition on obliging or encouraging someone to use a service provider, if one is an executive managing agent, you're ultimately making the decision. So there, the Property Practitioners Act doesn't even talk with the duties of a executive managing agent. Similarly, bond originators, bridging finance companies, and the works also are regulated by this Act. And when one looks at the Code of Conduct, which is an 8-page, and I really think it's quite shocking to see that we're trying to regulate such a big and broad industry on 8 pages. It's almost laughable, for lack of a better word. But unfortunately, we don't have the clear-cut answers. But for me, and when we look at the interpretation, it seems to suggest on behalf of another for remuneration. So it seems it's going to be the managing agency. But again, we don't know, and we'll have to wait and see what the BPRA comes up with before the 1st of October.
I definitely agree with your points about, who's going to want to be a trustee. I remember with with Poppy, when the information officer aspect was unknown, everybody was like, oh, the chairperson has to be. And suddenly people were like, no, I don't want to be chairperson, or no, I don't want to be trustees. And then lastminute.com, the information regulator came back to say, no, it can be the managing agent. At that point in time, the managing agents were thinking, this is actually something we don't want to do. And now we're being forced to undertake it. In this case, unfortunately, they don't have a choice, as with most pieces of legislation. But yeah, it's an interesting time. We don't have any more questions in the chat function. We have shared the legislation and all of the links. Does anybody online wish to raise anything, any questions, any of the managing agent, clients, trustees? You're more than welcome to raise your hand or say something now, Leigh-Anne. Yes.
I've got a question for Dilen, and I popped into my head now as we were chatting, and as a portfolio manager, it's a question that I'd like to raise. So when you make application to be a practitioner, you file the application, you get your certificate. Now what happens, and I had this question from a client about a week ago, what happens when let's say I move companies, I'm going to work elsewhere for another managing agent or whatever the case may be. Is a certificate transferable, or will I have to make a new application under the new employer?
Okay, so again, I'm going to say what the Act suggests, and then the answer from the PPRA, which is we don't know. So I'll start with that. The PPRA, we have no idea how they're going to implement it. But what we can see when interpreting the Act is they're now going to issue a Fidelity Fund certificate in your name. So it's not going to be Dilen Heerschop from Schuler Heerschop Pienaar holding this FFC. It's going to be Dilen Heerschop holding this FFC. So it seems to suggest that there may be some other notice where we now should notify them, or this is now me thinking as a reasonable person, a notice that we are now changing our employer or starting our own business, but our Fidelity Fund certificate is transferable as it's issued in your own name.
Okay, it makes sense, because I know that the clients, a lot of the managing agents, depending on how the structure of the company is, will make payment on the employee's behalf for the certificate.
Yeah.
So it'll be interesting how they navigate the payment thereof. You have to pay it back, whatever the case may be, if the employers are the ones paying for those applications. So it was an interesting question that I received.
Very much.
Yeah,
sorry, Dilen.
Yeah, I must say I'm quite concerned. Nearly and either did an immaculate job and there's no questions, or we confused everyone even more, so they don't have a question. I'll hope for the former though.
Yeah, I think it's a matter of a lot of information and something that people don't necessarily feel that they should be regulated on. I mean, the State Agency Affairs Board has never been spoken of very highly in the circles that I have traveled. One of our colleagues and clients that are online is still busy struggling with them. And there's 110 email addresses that you can contact. Obviously, no one picks up the telephone. And now it's a simple matter of it's, you know, the same thing, just dressed up a little bit differently. Yeah, and I'm glad to see that they at least have a different website address, because it was literally the same website, same email, same telephone number. It was just basically the colors that were different. So it's unfortunately a bit of a negative thing that in our very busy lives, we're having to comply with yet another piece of legislation. And because there's a deadline, we'll see a flurry towards the end, like we did with Poppy. You know, Poppy was coming and coming and coming, and then suddenly it was here, and everyone flurried around, and now it's, you know, a thing of a distant future, distant past rather. Ladies and gents, any questions for us? Don't all jump at once. You're getting away scot-free today, I think. While we're all taking a breather and absorbing that information, us at TVDM are offering the service of assisting you through the process. We are most certainly not going to do it for you. Nicole and I debated that quite extensively, and we decided no, we weren't going to put ourselves through that like we did for Poppy. We are simply going to ensure that you have the right resources to be able to assist you. Dilen, perhaps now's a nice opportunity to chat to everybody about the services that you're offering.
Yeah, thank you very much. So as you've heard, and I think when one looks at the outfit that I'm wearing, it's quite clear what industry I'm in. I'm either working for Mr. Delivery, or I'm an attorney. So luckily it is the latter in that case. So I'm an attorney. We are a boutique firm, or I like to call it a boutique firm. It sounds very nice. So we have branches in Pretoria, Johannesburg, and Cape Town, dealing with basically specializing in our client's problem. But from my side, I've taken the bad decision to specialize in property law, and then specifically the law pertaining to community schemes and any compliance aspect related to that. That's why I also had to navigate the Poppy waters and now also the PPA waters. So, basically anything ranging from litigation in a community scheme context, so election of levies, to just in an advisory role dealing with compliance aspects in community schemes.
Thank you very much. Any questions from the audience? Comments?
Dilen, I've got a question for Dilen. or
Thank you,
for
Carl.
actually anybody. Dylan, can you take care of this whole process for me? Because I've been trying for 6 months to sort something out with the EAB, and now I've sent 2 emails with queries again to the PPRA. There's just no reply, and I'm not sure if I'm not contacting the right person. I just don't have time to waste my time on all of this.
Yeah, Carl, so what I can tell you is we've got the means to get the horse to the water, and as attorneys, we can also make the horse drink. So yes, you'll have to just contact me relating to the issue that you have. Luckily, we are now dealing with administrative decisions, which is another nice piece of legislation, which is the Promotion of Access to Justice Act, or PAJA, as people would call it. And we deal with these types of things. So we're looking at yanking the chain at the PPRA at the moment. I mean, we are going to bring this application and try and engage with them. But at the end of the day, if they don't want to engage, then we make them drink and then we go to court. So it'll at the very best depend on your litigation appetite and whether or not you want to see this matter through. But if you want, then we'll make the horse drink.
Fantastic. Thank you so much.
I like that analogy.
Anybody else? All right, we've got a quick question on the chat function. If I must register and the regulations do not give proper qualifications, what then?
Okay, Leigh-Anne, so I think this is two-faceted. The first part that we want to discuss is whether or not you complied with the EAAA, or the Estate Agency Affairs Act. So in terms of the Property Practitioners Act, if we've already complied with all of the regulations in the EAAA, so we've registered, we've obtained our FFC and all of those things, there is a transition, which means they will recognize you now. If you have been recognized by a previous act, yes, you can. Otherwise, you will have to register and we'll have to wait and see what they say regarding the qualification. So it will depend on your current qualifications. But if we're dealing with candidate property practitioners, hopefully within this month, and I mean, I'm very optimistic and cautiously optimistic with saying this, but hopefully we'll get the guidance we need. I mean, there's a lot of things that has to happen before October. So it's we're in dire need of some assistance at this time.
And I think, well, myself as an attorney who is a portfolio manager, I would also, when you're looking at the qualifications they are prescribing, I would be interested in applying for an exemption of some sort, because I think my qualification holds the same sort of weight as the NQF4 that they are prescribing. That was originally, prior to 1 Feb, that was what was required, and now we are not too certain. So it will be interesting to see how I can go about that, and if I could actually indeed do so.
Yeah. No, but again, I think it's either going to be guidance from the PPRA or some other managing agent or industry which is fed up, and then we'll have to take them to court to get these guidance. But at some form or manner, we will have to obtain guidance or interpretation or anything where we can now actually affirmatively answer all of these questions. Because for now, it's basically we don't really know, but this is what we do. That's how it feels to me when having to discuss the Property Practitioners Act.
Zulfa asked a question as well. She's actually my boss, and she's been dealing with the EAB for her own Fidelity Fund certificate, and then she mentioned the logbook. I know prior to 1 Feb there was this logbook you had to submit as well. Is that now, do you think it will be a thing of the past or still something to continue with?
Yeah, so what I can tell you is the Property Practitioners Act and regulations don't make reference to this logbook, but let's not steer away from what the logbook actually envisions to do. So for us to be a property practitioner, as you've mentioned, firstly, one would be suitably qualified. What this qualification entails, we don't know. And from the other aspect of this is one would have to be suitably experienced. And I mean, a logbook is basically just evidence of us now obtaining this experience and what we've done in our endeavors as this candidate property practitioner. So even though I want to be excited and tell everyone the Act does not make reference, just be cautiously optimistic again, because it may very well just continue under the Property Practitioners Act. And then just Leigh-Anne, for your side, your boss contacted me as well, and you can have the rest of the day off. Okay?
Oh, lovely.
Gonna double check that, hey?
Yes, I will.
Yeah, it also says, yeah, right.
Got lots to do.
Fantastic. Well, ladies and gentlemen, I'll give you one last chance to ask any questions. Otherwise, we will go and grab another cup of coffee and expect that you'll be flooding Dilen and my inboxes with all your comments and your questions that you don't want to ask online. Tony, I saw that you unmuted yourself. Do you have a question for Dilen or Leigh-Anne?
Yeah, just one question, just to clarify. So if we've got our FFCs, we are registered, we've got everything in place, that we still have to re-register with the PPRA?
So again, and this is the problem. There's no guidance. My advice would be, and I would accept in an entity like this, that they would have transitional things where they now actually just export the current information that they have and import it into their new PPRA system. But to err on the side of caution, my advice would always be rather comply with what they want us to do, as opposed to taking the stance they already have my information, so there's no need for me to re-register. I know it's not very nice. It's going to be a mammoth task. I mean, there's a lot of things that needs to happen now under this new act, but let's just get our house in order so that we know that there's no speed bumps, for lack of a better word, from our side. Let's try and ventilate this thing and make it occur as seamless as possible. That would be my honest guess.
Thanks.
Yeah, and as Linda mentioned, remember, speak now or forever hold your peace until you email us. This may be the last time that we don't send you an invoice for your questions. So please use this space now and use it wisely.
Speak for yourself. Nicole's always moaning at me that I don't invoice enough. So I'm sure we'll still give 1 or 2 freebies outside. Well, if nobody's got any important questions, I will share some very important information, which is not work related. But my little 6-month-old girl, almost 7 months old, crawled for the first time this morning. So we're now going to go and fill up all the plugs with little stoppers so that she doesn't stick her fingers into it, and going to not have to take our eye off her for a second. But that's how quickly time flies. So
I'm just going to say good luck to never being able to sit still again from this point on.
Wow, congratulations, Alinda. That's amazing news.
Thank you. It's apparently what they do round about this age. So she's on track. But that just shows you how quick time flies. So before we know it, we will be sitting on the October deadline. Then you would be sorry that you didn't ask all the 110 questions now. But in any event, we're not going anywhere. We are here for you. So you are more than welcome to contact us whenever you need assistance. Dilen and Leigh-Anne, thank you so much for your time and for your expertise. If anybody would like Dilen and Leigh-Anne's contact information, we will post it on our website along with this presentation. And for those of you that attended us this morning, thank you very much. And do not forget to sign up to our newsletter. And if you would like to discuss any further matters in regard to the DA matter that we told you about and the CSOS complaints, please do follow that link or make contact with us as well. All right, on that note, thank you very much and have a fantastic day further. Keep well, everybody.
Thank you so much.
Thank you.
Bye.
Okay,
Bye.
Bye.